put the correct information.
What was the assertion by counsel yesterday
the,
regarding those numbers?
The assertion was that the...
My lord, it's wrong for the state to respond on my behalf. I'm the one who was cross-examining.
No, please. There's decorum in court. It's not a tavern. I normally attend taverns in Soweto.
I don't attend taverns.
Yes, that's why you don't know what happens in a tavern. Maybe even the deceased was not shot in the house. Yet nobody is saying that in the cross-examination, as I'm following the cross-examination.
Unfortunately, I'm not finished.
No, I'm talking about the defense itself.
Excluding number 5, my lord.
Hello?
Excluding number 5.
No, you have not stood up yet.
Thank you, my lord.
But first, second, and unless you are going to say that.
I'm not done with my cross-examination.
Okay, but
yes.
The first two counsels, Mr. Mnisi and Rampesele, they never said there were no two persons who entered the room. There were no shots fired. Well, there's a difference. There could have been 2 shots or 3 shots, and one was loud and one wasn't loud. And this witness can't describe what a firearm looks like because he doesn't know. And you read him a statement of Longwe who says it was a 38. What is this case about, actually? That's what I'm getting at. Because if you're a defense counsel, I would expect you to say, I put it to you that there were no intruders who went into the house, and there were no shots fired inside the house. I haven't heard that. Mr. Baloyi, am I maybe?
It's still coming with
it's still coming.
5,
Okay, fine.
Can we just pause here
until
I start my case?
It's still coming with
yes,
me. Fine,
it's still coming with me.
I'm just saying the counsels I've listened to so far.
1 to 4.
Up to now, maybe after when he comes back, the counsel for the 4th,
yes.
you will put
yes,
something.
I'm definitely not done.
I do.
I'm not done, my lord. I'm not done with my cross-examination.
Okay, fine,
yes,
fine.
yes. Thank you.
But have you said that, Mr. Rapper?
Basically, my lord, it's an issue of identification.
Yes, no problem.
That's our difference.
No problem.
Identification only.
I'm not talking about identity. I'm talking about the fact that 2 intruders got into the house. Are you disputing that?
I wasn't privy to that. I don't know.
No. You've got a statement from the client to say I wasn't there.
Yes.
So it means you are disputing that, or what? Are we on the same level?
We are on the same level. We are on the same level.
So you're saying there were not 2 people who got into the house, isn't it? Is that what your instructions are? See? Are those your instructions? How should be here the whole year? Are your instructions that no 2 people intruded into the sanctity of the house of the Kumalos?
If my lord listened to our case, they said they were not there. So
no, the clients were not there. That I've heard.
Yes.
The question is, are you further saying no 2 people entered the house of the Kumalos? That's all.
That's the bottom line. If I say identification and then we are not there, obviously they are saying presupposition is that there were not 2 intruders, my lord.
But why didn't you put it there? You cross-examined the whole day the other day.
Yes.
You never put it to this witness that no 2 people entered the house of the Kumalos. You never had any dinner or lunch. Makumalo never cooked soup for Lolongwe. I'm listening, and I'm saying, so the evidence so far, which has been put to this witness, is about identification. No problem about it.
Yes, but that was the version according to that was the version.
And your client's version is he was arrested in Rustenburg, taken to Carltonville.
Yes.
In other words, he wasn't there.
He wasn't there.
On the 26th of October, 2014.
Yes.
So he can't tell this court whether the 2 people intruded or not.
Yes, that's what I'm saying. It's difficult.
That's the same with you, Mr. Mnisi.
That's so, my God. Whether there were 3 or 5 or 100, we don't know.
That's it, yes. That's why now when we come to delineation of whether there were 2 shots, 3 shots, one was louder than the next one, how does it assist this court in coming to solving this conundrum? Are you with me?
Court pleases, my lord, I'm the defense, and the duty is not upon me to prove. The duty is not upon me to prove the authenticity of this document. It is for the state. Because I want to question this witness in terms of the contents of that statement. So the authenticity thereof. By whom, my lord? Because the witness doesn't say.
It says the commission, but that's not his regular police station. That's why it says this John will be known to this police station where.
Yes, but if it does not show it's only the signature that is the first number. How many Johns do we have?
But you haven't noted the statement.
It's an original statement.
Yeah, look at it. Because you haven't had sight of it. From what you're saying.
Yes.
If you had sight of it, you would know what it is.
But what is of importance, the duty applies upon the state. I want to cross-examine on that statement. I'm not the one who's going to call John to prove
Mr. Malloy, I'm disputing that this statement was not from you.
Well, on the face of it, my lord, the statement was commissioned. And if the witness doesn't dispute the statement, so my understanding is the process of the statement. Basically, it has been proven once the witness identifies the statement as his, then you can cross-examine.
No, these are not the requirements for proving the authenticity of the document, or in terms of the commission, that act, of the Commissions of Oath Act, the stamp duties, I can't cite it as it is, but there are certain requirements that we need to comply with. So even if you can identify the statement, the same situation happened when I was leading evidence, when I was cross-examining Mr. Sergeant Mkhola about the person who doesn't appear at the end of the statement. The court had serious questions about that affidavit. So it's the same situation here. They must prove who that John is, because there's no first number.
Why do you want to do it?
I want to make the statement, not a statement to be admitted, because that evidence that I want to elicit from this witness is the evidence that has been created now. The statement, unless the state wants to call it John with no first number. So let's just leave the statement. For the sake of progress, I'm not going to take you on that statement. I can see you did not make a statement to prove that you retrieved 2 cell phones from accused number 1. Let's just forget about that statement. Lastly,
Inkosi enkantolo, ngiyacabanga ukuthi nginalo ilungelo lokuphendula. Ukuthi samukelwa istatement okanye samukelwa, kodwa ngiyacabanga ukuthi nginalo ilungelo lokuphendula.
I think I have the right to reply to this.
Okokuqala nje kuyihaba kule nkantolo ehloniphekile ephakeme kakhulu ukuthi angufakanga lokho. Ngoba ku paragraph 6 kukho khona.
No, I don't want to get into that statement. Listen, Baba, listen, wait. We are not, we are in court here. We are not writing tickets or traffic fines. We are dealing with the court, evidence in court.
As a court case, we have the papers. It's unfair for Mr. Bongani to speak down this like that. It's the first thing. Secondly, the court asked us earlier on as to whether this statement is properly commissioned. It's properly commissioned. The place is Johannesburg. There's the name of the commissioners, Senzo Meyiwa. So on the face of it, the statement was properly commissioned.
Yeah, I'm not interested in that statement.
John is Johannesburg.
John is in Johannesburg. So we must call Johannesburg to come and testify. because John there's no first name.
Can I look at that document? You're saying it's a document. Yes, it is now.
Sorry, my lord, if I can say something.
Yeah.
I take offense in what the defense has just said now about writing tickets and what. This is a court. This is not a boxing ring, and he must take his emotions somewhere. Here I'm here to answer and to respond to his questions. So if he feels that maybe I'm so undermined in that fashion, like I said before, it was said in this court, and he's repeating it. I take offense in it. That he must know. He must keep his emotions to himself.
Let me just put it this way. I won't enter into any dialogue with him. If I say I'm not going to proceed on the statement, then you want to insist on paragraph 6, you are undermining me. I'm the one who asked the statement to go to you. You are undermining me. So hence I retracted that statement. I was not expecting anything from that statement. So you want to read the statement by force. You are undermining me.
Some Gomezulu put it to the witness that you have mentioned in the statement that 2 cell phones were recovered. Now the witness says in paragraph 6, I didn't mention that. Now it says it's undermining.
No, but my lord, let us be honest. I said, before you even said that, I said I don't want to, I'm not going to ask any question from that statement. So he insists, he wants to read paragraph 6. There's non-compliance with that statement. That's the reason why I'm saying that statement, I'm not going to use it now. So you want to insist and say paragraph 6.
When are you going to use it?
I'm not going to use it anymore. I'm going to submit that everything that is said. My lord, if I may address the court. May I address the court? My lord, from the trend of what is happening here, I asked Mr. Kennel Hose about paragraph 15.2.2, where it dealt with 1 cell phone. He never mentioned about other 2 cell phones. When Mhola took the stand, she mentioned 2 cell phones. Then I asked her whether was accused number 3 arrested with 3 cell phones. She said no, 2 cell phones. Now because they keep on fabricating, manufacturing evidence, now they are bringing this witness to put more spice in the pocket course.
The court is entitled to read the statement because the statement has been handed to the witness. But you, Mr. Mnisi, you are now saying you are no longer interested.
I'm not interested.
I, as the court, am interested because there are allegations and assertions which you have made regarding the statement. One of them is...
My lord...
Wait. One of them is saying it was only made this morning. That's now. Remember that.
My lord, may I put the court to the position where it is?
Yeah.
You are not a party in this proceedings.
No.
No, my lord. You cannot descend into the arena. You are now descending to the arena?
By doing what?
No, by reading the statement. That's not the prerogative of the court. That's not the prerogative of the court. This is not what is disclosed and hand up properly in terms of the law. You can't do that. You are descending into the arena, my lord. Yes, my lord. Please, if so, please, is the court.
I'm sure you've heard of Section 186.
No, I know 167. I know 167. And we can read the 186.
Okay. Any document which is flying around in court, this court is entitled to have access to.
But it must make provision if a witness is under.
186 to you, I'm asking you, do you know about 186?
No, my lord. You said yes. But I won't allow the statement to be read now. Not that I'm running away from that paragraph 6. It does not comply with the requirements to prove the originality and the authenticity of the document.
Yes, go on.
Let's proceed, Mr. Lieutenant.
Before the examination, I'm being accused by Mr. Mnisi of descending into the arena. I've long told you I'll never do anything which is not permitted by the law. Now listen to what the law says about me. Section 167, the court may examine any witness or person in attendance the court may at any stage of criminal proceedings, any stage, examine any person other than the accused. That person who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings. And the court may recall and re-examine any person, including an accused who is already examined at the proceedings. And the court shall examine or recall the person concerned if his evidence appears to the court essential to the just decision of the case. So what I was doing, that evidence, according to this witness, you put it to him that in his statement, he never mentioned the 2 cell phones, right? And when he wanted to respond, you said, no, you're no longer interested. And according to me, those 2 cell phones are material for this case. That's why I was using this. So I want this witness to testify about that. He's being re-examined. He's being examined by me in terms of section 166. Sorry, 167. Because I think that evidence of this person concerned, let me tell you this. On this date, the terms of that evidence, they seem proper for me to examine him and to find out, because this evidence is essential to the just decision of the case. So I'm not descending into any case where I am partial. The law entitles me to do that.
May I respond?
No, you don't have to respond. Why do you want to respond? No, you don't have to respond. You've already said me, I descend to the arena. And I'm telling you I don't. I'm doing it in terms of section 167.
It's me who made such a submission. I want to support it. With all fairness, if the court quoted section 186, now I want to correct the court. Taking from the maxim, jus dicere non facere, jus dicere non dare. My duty is to interpret and apply the law. The court, these provisions deal with a situation where the court is empowered to examine, not to examine at the time the defense is busy. This misinterpretation.
Okay, let's listen to what it says. It's nothing like that.
You are still examining.
No, nothing like that. It says, the court may at any stage of criminal proceedings, any stage, whether you're examining or not, just give this gentleman this, that's by the way. Just give him. Because he says it's when he examines. There's nothing like that. At any stage. Just give it to him.
If maybe the state can be of assistance, there was an allegation made of recent fabrication, so the state is in any case going to take up that statement with the witness.
Okay, fine. So I'm not descending into...
No, but I can see the state and the court are colluding. They are both colluding. The court is always on the side of the state.
Now I'm colluding.
No, you are colluding. You are dissenting. You are impatient, my lord. Everything. Look now. That statement
so
is not
I'm in the mind of Mr. Baloyi.
My lord,
he stands up there, is obviously colluded with
I have retracted that statement. Where is the privilege of the court to take the statement to the witness? The statement is not discovered to the court.
I said I'm going to do it.
It's not hand up.
No, it doesn't have to be hand up.
That's irregular.
That's it. Then you take your key.
Yes.
And I hope you succeed.
Thank you.
So, Mr. Buthelezi, you said in your statement, you did mention about the 2 cell phones.
Yeah.
This is correct.
Can you read that paragraph 6? Because we said paragraph 6 or 7, where you mentioned 2 cell phones.
Okay, go paragraph 6.
Paragraph 6?
Mawuyale egcineni.
Towards the end?
Ngikhuluma nge-ammunitions.
No, Read the whole paragraph 6.
Paragraph 6.
Ku paragraph 6 iqala kanje ithi the ammunition was counted in front of him, and I asked him if he was licensed to possess these ammunitions, and he said no. I further informed him that I will be opening a case of possession of unlicensed ammunition. All our conversations were in Zulu, and he understood. I again warned him in terms of Section 35 of the RSA Constitution that the ammunitions were put inside a forensic bag number PA 5001 806984. His cell phones were put inside the forensic bag number PA 5001 806986.
That statement, has it been commissioned?
This statement is commissioning.
Yeah.
That is correct.
And have a look at it because they say it is not properly commissioned. I'm just interested in the commissioning. It's a statement with 9 paragraphs. And the last paragraph says, I know and understand the extent of this statement. I have no objection to taking a prescribed oath, and I consider the prescribed oath to be binding on my conscience. And it is signed by the accused, and it is also signed by a gentleman who terms himself Johan. And he terms himself as a commissioner of 8 oaths. And he gives an address on the commissioning. So this court is satisfied that this statement was properly commissioned. What does the exhibit say? Yeah, probably you must mark it because of old age. Yeah, right. And we understand the reason. You mustn't use waves you don't understand. You don't want this to pollute.
My Lord, I'll use that word in a literal way.
No, just listen to me.
I understand
You
that.
mustn't use the waves you don't understand. What is to pollute?
Maybe I mean it. I might not understand it. Maybe I mean it. Because now, my Lord, may I respect the court by saying this? But Lord, you just said now. That's it. That's what you're doing, my Lord. With due respect. And I'll stand by that. And I'm still preparing my 317.
No, do it.
No, my Lord, you just mentioned my Lord now. He said this statement was commissioned by Vosmus Mkhani. You say, as the court, you say it was commissioned by another person, Johan.
How am I colluding with him?
No, but he said it was commissioned in Johannesburg. The court says it's another gentleman, Johan. But Mkhani, he said...
No, you see, I never said it's another gentleman.
That's what you said, my Lord. Let's just rewind it.
You don't have to rewind it.
No, let's just take the records for that. This is what you've said. You said this, you are satisfied that this statement was properly commissioned by the gentleman, by Johan. And the state said it was Vosmus Mkhani in Johannesburg. Please, my Lord, let us be honest to this.
You mustn't use words you don't understand.
No, may I retract it?
You mustn't use words you don't
May
understand.
I retract
You know
it?
what? I've got the right to sue you.
My
know
Lord,
that.
my Lord.
Maybe you don't even know that law.
No.
I've got the right to sue you.
My Lord,
because you are impugning my character and honest. Maybe you don't know that.
My Lord, may I address the court?
Colluding.
May I address the court?
No, you don't understand.
My Lord, may I remind the court about the witness that you didn't treat very well?
You don't have to say anything after this, please.
Thank you.
Yeah, you don't have to say anything. Okay. Yes, Mr. Banoy, what time is it now?
Well, I have one question arising from the court question, just one.
Which one is that, ma'am?
Can I ask it now?
Yeah, fine.
Thank you, madam.
Yes,
ma'am.
Instead, 1301, maybe we can take the long adjournment and come back at 2.
But I was not going to be long, madam.
But the state did not re-examine the witness.
After lunch.
But the court was
Yeah, after lunch. Thank you.
But, counsel, didn't you say your client admits that that is his number?
No, my lord, we denied that number. We admitted the...
Wait.
Yes, ma'am.
It's 277887989.
99.
It's only 19 here.
It's only 19, yes, my lord.
98335.
Yes, we
And
did.
this was captured on the 24th of November 2012.
Yes. We denied that one, my lord. There are two numbers in the same paragraph. They are the same.
Which one does your client admit? Because I have it on my notes.
It's the one which...
Which one?
0733-059202. Just above that one.
That he says it's his number.
He admits, yes.
That's the only number he admits,
He
out of the
admitted-
5.
Sorry, madam?
Out of the 5, there are 1, 2, 3, 4, 5 numbers.
Yes, he
only
admitted.
admits 1.
In paragraph 24, he
Okay,
only
fine.
admitted one.
Okay.
So, please, that is not correct.
Yesterday, wait. Yesterday was not put the way I'm putting it.
He did. It was also admitted that he admits that number ending with 176 that it belongs to his mother.
Yes. Anyway, fine. Let's proceed. You remember the mother of Tembegile, blah, blah, blah. Mother Batembegile. Who's the mother of accused number 5? He knows the number. That's how you put it. Number 5 knows the number because it's a mother's number, but the mother is deceased. You don't remember saying that?
No, my lord.
Mr. Baloyi, wait. You remember somebody was deceased?
Yes, that's precisely what it was said.
Yes, I listen and I write notes.
My lord, I've never said that we are changing what we said in respect of
Okay,
the
fine.
number
Let's
belonging
continue.
to the mother of the accused.
But
I've never said anything about that, and I don't know the reason why the state is standing up when I'm cross-examining. Because you can note down and do that in re-examination. That's not the procedure to disturb when counsel is doing cross-examination.
That's a good. Well, firstly, my colleague doesn't have to raise her voice, and secondly, we submit that we are within our rights to put the correct information.
What was the assertion by counsel yesterday?
Well,
regarding those numbers.
The assertion was that the...
My lord, it's wrong for the state to respond on my behalf.
No,
I'm the one who was cross-examining.
No, please. There's decorum in court. Yes. It's not a tavern. I normally attend taverns in Soweto.
I don't attend taverns.
Yes, that's why you don't know what happens in a tavern.
The assertion was that the...
My lord, it's wrong for the state to respond on my behalf. I'm the one who was cross-examining.
No, please. There's decorum in court. Yes. It's not a tavern. I normally attend taverns in Soweto.
I don't attend taverns.
Yes, that's why you don't know what happens in a tavern. Sir, just clarify this. These 4 numbers, how do you record them? The 5 numbers?
Yes. What was put, my lord, as far as I have it, that the number 07697355176 belongs to the late mother of accused number 5.
Right. And
that her name is Batetele Zungu.
Right.
And that the number 0733059202 is being admitted as belonging to the accused, or the number that the accused used.
Okay, fine. Yes, can you proceed then?
And then, my lord, I let the same witness in respect of the other affidavit, which is marked Exhibit DD5C, paragraph 9.2.1. Above this, wherein I indicated the second number, my lord, which you admitted as the number belonging to accused number 2. It was not on this affidavit, which is affidavit DD DD5. It was on the affidavit marked Exhibit DD5C. On paragraph 9.1 of that paragraph, I put the version to this witness to say we admit number 0766427007. We admitted that number, my lord.
Yes, what's your comment, sir?
She admitted what my lord.
Yeah. I was clarifying that those are the two numbers that we admitted.
Okay.
But the second one, it's not appearing in paragraph 24 of Exhibit DD5.
That's correct.
It's on the other affidavit.
That's correct.
Thank you, my lord. May I just have a word with my client, madam?
Yeah, fine, but just to add,
Yes,
this evidence, we are traversing it for the second time, because I actually wanted to know on which particular dates did the credit
Consumer
Bureau
Yes. My lord,
annotate these numbers, and I actually wrote them. That one was on the 24th of November 2012, the other one was on the 21st of January 2015, the other one was on the 29th of January, on the 15th also of January, and the other one was on the 24th of November 2012. And I also requested, how does the Consumer Council link these numbers? And the answer was that they are all linked to the ID of accused number 5, because it wouldn't make sense if I take credit at OK Bazaars and I don't give them my ID number. How will they know who am I? Because they may have a name and an address. And this is the phenomenon which actually plays itself in South Africa, where you find a guy steals your ID and then goes to Labnas and buys furniture as host. Okay, you've heard me.
Actually, my lord, I was taking up from where we ended yesterday after reading the examination in chief of the witness, wherein he referred to these numbers.
Yes.
Especially the first one, that he linked it because it was saved under the name Reggie.
Yeah, fine.
Yes.
But he linked all 5 of them to the Consumer Council.
Yeah, that's what I was saying.
That's
what I was putting to the witness is what he said
on
record. That's why I read the evidence on record and the pages.
Okay.
Wherein he said it was saved as Reggie.
Okay, fine.
Yes. And the witness said, no, he cannot deny that.